Welcome to The Source, where we combine the headlines with in-depth conversations with the newsmakers themselves. I'm Pinky Webb. Today on the program, the Philippine government remains unfazed by the International Criminal Court's probe on the administration's war on drugs. But families of drug war victims are hopeful that this is a crucial step in attaining justice. To what extent can the ICC flex its powers, and will its probe without government cooperation amount to anything? Retired International Criminal Court Judge Raul Pangalangan joins us live. Government officials insist that the International Criminal Court has no jurisdiction in the country over its supposed probe on the Duterte administration's war on drugs. Presidential spokesperson Harry Roque and Chief Presidential Legal Counsel Salvador Panelo both insist that the country's judicial system is working and the case will not prosper. Let's go straight to the source of the story. We have retired International Criminal Court Judge Raul Pangalangan. Judge, it's good to see you again. As I told you off the air, it's been a long time. Okay, I want to start this conversation, this interview, by first understanding your position, because you joined the International Criminal Court, I believe, in 2015. And from my understanding, the judges are given a 9-year term, but you ended your term in 2021, which makes it only 6 years. What happened?
Thank you for that question, Pinky. The regular term of judges, you are correct, is 9 years. The first 3 years were actually used up by my former professor, Senator Miriam Defensor Santiago. So she was elected to the post. She never took her oath because she remained a senator of the Republic. So she never sat as a judge. But when eventually in 2014, she told the court that for health reasons, she is unable to take up the office completely. Then the court had to call for fresh elections. So I did not inherit the seat just like that. I had to campaign afresh with all the member states of the Rome Statute. I had to stand for an election against another candidate. In fact, there was a third candidate earlier, the former Chief Justice of Bangladesh, and I won that election. So I served the remaining 6 years of that term until early this year.
I see. All right. So you ended your term, I believe, in March 2015, along with 5 other judges. I was reading at I was looking into the website of the ICC, and it was in March that 6 other new judges were confirmed as members of the ICC. And looking into the composition of the ICC, I saw that it's composed of 18 judges. And am I right in understanding that it's divided into 3 chambers, which are the pre-trial, the trial, and the appeals chamber? Would that be correct?
That is correct. But Pinky, the term we use is 3 divisions. So these are 3 big divisions of the court. And then the divisions will perform their function through chambers. So a pre-trial chamber, a trial chamber. So, but you're correct. The 18 judges are designated to different to the divisions. Yes.
Okay. So if you're a member of the pre-trial division, you are not a member of the trial or the appeals division. That means all 18 are relegated to either one of the divisions, the pre-trial, the trial, or the appeals.
That is correct, Pinky. The unique thing, though, is that if you're in the trial or the pre-trial division, you can actually get designated to work in the other division, because the only constraint is for those in the appeals division, because we try to avoid any conflict of interest, that they should not be involved in any of the cases before them in its earlier stages. So even when I when I joined the court, I was first in pre-trial, but all my work was in the trial division. And then I was in the trial division, I can still do some work in the pre-trial division. Yes.
I understand. All right. So the ICC authorized a full investigation into the country's war on drugs. So I saw that it was only signed by 3 judges. Would these 3 judges be part? Are they the judges of the pre-trial division? Because as I looked at the website, I saw that out of the 18, there were about 8 who were designated as part of the pre-trial division or chamber.
Those 3 judges were designated by the court to sit as the PTC, the pre-trial chamber, for a set of cases, among them the Philippine case. And then, Pinky, when assuming this case moves forward into a full trial on the merits, there will be an entirely new set of judges designated for trial to sit in the trial. 3 judges who until then would have had nothing to do with the case. So there will be a fresh set of judges at that stage.
So it's going to be 3 of the other 15 judges who were not part of the 3 judges who form part of the pre-trial division. Pipili doon sa 15 na naiwan.
Yes, in fact, it's not even the remaining 15. It's the I would say the remaining 5 or 8, the remaining 7 who have not been involved in pre-trial and who are not in the appeals chamber.
Oh, that's
so
right.
Those are the judges. And by the way, Pinky, unlike in the Philippines, the judges are not assigned to cases by a raffle. They are appointed by the presidency, by the president of the court, depending on the flow of cases, on the caseload of the judge. Because as soon as a trial kicks in, a judge sitting in that trial chamber will be booked solid for almost everyday trials. And so they have to find a judge available to sit afresh in a new trial.
And as you mentioned, they have to be able to look into this every day. So you were saying it's an everyday trial. So looking into the decision, Judge Pangalangan, it said that 2 things that struck me. It said that on the basis of the above, the chamber concludes that there is a reasonable basis for the prosecutor to proceed with an investigation in the sense that the crime against humanity of murder appears to have been committed, and that potential cases arising from such investigation appear to fall within the court's jurisdiction. Again, I'll repeat those 2 points. The crime against humanity of murder appears to have been committed. That's one. And the second one is that the cases arising from such investigation appear to fall within the court's jurisdiction. So let's talk about that. The investigation actually covers the years 2011 to 2019. President Rodrigo Duterte became president in 2016. So why does it actually even cover the years prior to his presidency?
You have raised a very good point, Pinky. Indeed, that is something that is most remarkable. There are many possible interpretations, Pinky. The most innocuous interpretation is that it's also expressed in the decision of the pretrial chamber, is that the philosophy is that this is merely a permission for the prosecutor to proceed with the investigation. So we shouldn't bind the hands of the prosecutor too tightly. You must give the prosecutor enough latitude to inquire into a situation, because maybe in the course of that investigation there might be useful evidence of the crimes that were committed. That is the most innocuous, just to give enough latitude to the prosecutor. Of course, if one will look at this with some sense of political, what people think are political motivations, maybe they would say that, there's one thing in common between that period in Davao, and that this period now at the national level, and that is there was the same that the mayor in Davao then is now president of the Philippines. But for me, that is giving too much of a political color already to the decision, because the crime against humanity of murder can be committed either at the local level or at a national level, and we call it the temporal jurisdiction of the court existed anyway, starting 2011. So for me, it is par for the course for the court to give such permission, such latitude to the prosecutor.
Is it to connect in one way or another a pattern on this war on drugs that resulted to the deaths of thousands? So even if President Duterte took office in 2016, the court wants to look into possible patterns prior to President Duterte's presidency, basically when he was mayor, and obviously looking at what is said to be the Davao Death Squad.
The pattern that you mentioned, Pinky, is actually covered and expressly noted by the court in the pretrial chamber in its decision. So that is yet another another implication that one can derive from the broad temporal jurisdiction, temporal scope of the authority given by the pretrial chamber. So yes,
right.
My short answer is yes. It is possible that expanding the scope of the investigation all the way back to 2011 might be for the purpose of establishing that pattern. Note, Pinky, that an element of the crime. These are the stuff that will have to be proved in order to convict a person. An element of the crime is that the attack on civilian populations should have been committed in the course of a state or with a state or organizational policy. So again, maybe that's part of the pattern that the court wishes to establish.
And so going back to the point I was raising, was the first was the crime against humanity of murder appears to have been committed, that's why there's an investigation. And the second point is that these cases arising from such investigation appear again to fall within the court's jurisdiction. So this is the second point I wanted to raise with you, Judge. Appears to fall within the court's jurisdiction. Chief Presidential Legal Counsel Salvador Panetta was saying no jurisdiction because, number one, two things. The Rome Statute never took effect as it was never published in the official Gazette. But there have been many explanations about this already. Yes. It being a treaty, the Rome Statute at that doesn't really need to be published in the official Gazette. I'm just going to go to the next one, which I wanted to really focus on. The second point was that the government's withdrawal from the statute took effect March 17, 2019. However, it was former ICC prosecutor Fatou Bensouda who started the preliminary exam. There's always a mistake there. So here's what we call the preliminary examination in 2018. So Judge Pangalangan, is it clear that the ICC still maintains jurisdiction over possible crimes prior to the effectivity of the withdrawal last March 17, 2019?
My answer, and also the answer of the pretrial chamber in this decision, is yes. The court retains jurisdiction over crimes committed within the Philippines while the Philippines was still a member of the Rome Statute. I saw an interview of Secretary Panelo where he makes a distinction on the effect of the withdrawal on continuing jurisdiction in contrast to the duty to cooperate of the court, that is, of the state, the duty to assist in the investigation. And Secretary Panelo has a point, because the applicable article, which is 127, uses a different language to explain the effect of withdrawal from the effect of withdrawal on the duty to cooperate, and in contrast, the effect of the withdrawal on whether the court can continue to hear the case. But I think despite the different language used by the court for those two different items, I think we will still end up at the same spot, that the withdrawal does not affect the court's power to hear the case and the duty of the state to cooperate in the investigations of the court.
Good points you mentioned, Judge Raul, because I was thinking about it just obviously as a layman. It would be, would you say it, very wrong or unjust for any state to think, any country at that, to think that upon withdrawal, the ICC does not hold any jurisdiction anymore. Because if any any official of a country undergoes any preliminary examination, then the country would easily just say, I'm going to withdraw rather from the Rome Statute, and that does not make that person liable anymore. So there has to be obviously something within the Rome Statute and the ICC that makes somebody liable, even if you actually withdraw from the Rome Statute.
That is correct, Vicky. In fact, if you look at the preamble of the statute, when the court was established, the goal really is to end impunity, because historically we have seen that people can commit crimes and then afterwards, walk around completely unpunished, and that is the goal of the court, to end impunity. So you are correct, Pinky. The continuing jurisdiction, despite the withdrawal, is part of that entire mechanism.
And before I close this topic, Judge, that means plain and simple that from March 16, 2019, and the years and days prior to that, that will be covered by the ICC.
In fact, it goes all the way back to 2011 when we became a party to the Rome Statute. We will have jurisdiction over all crimes committed within Philippine territory from the moment we became a member of the court.
All right. We need to talk about the evidence and what the ICC will be looking into, and of course, the government stand that it will not cooperate with the ICC. What kind of effect will that have? But we need to take a very short break. The Source will be right back. You're watching The Source on CNN Philippines. I'm Pinky Webb. Our guest today, retired ICC Judge Raul Pangalangan. Judge, there's still so much to talk about, but I want to look into the evidence. The court or the chamber considered evidence of about 200 victims. The evidence on behalf, rather, of 204 victims. Is this where it actually decided to proceed investigation because of what was looked into, analyzed, and concluded preliminary on behalf of the 204 victims? And my follow-up question would that be is, can the court still allow additional evidence on behalf of families over and above the 204 victims?
Yes. Let me start with your last question, Pinky. A categorical yes, of course. The court will, in fact, now that the pretrial chamber has given permission to proceed to an investigation, this is the stage when specific evidence will be sought by the prosecutor in order to establish, in the end of the investigation, in order to be able to file charges, indictments against specific persons. So yes, the search for evidence will have to continue, and this time it will be evidence not on a general matter, which is the Philippine situation, whether there are crimes being committed in the situation, but at that stage, more specific evidence against specific people and crimes committed by those persons. I must emphasize also, Pinky, that the role of victims within the court's system is, how should I say this, is more engaged. The victims are more engaged in the ICC than what we are more familiar with in the Philippines. In the ICC, victims have their own counsel sitting in the courtroom. So judges deal with three sets of counsel: the prosecution, the defense, and the legal representative of victims. They do get to participate in the trial. They get to question the witnesses. And assuming there is a conviction, there is, of course, an entirely separate stage of the proceedings for reparations for victims.
So you said three basically sets of people: the defense, the victims, and their legal counsels. So what if there's no representation from the defense? Basically, what if government does not cooperate? Is there such a thing as the case proceeding without the Philippine government's cooperation? Can that happen? Is it called trial by absentia?
Well, I will make a distinction. The case and the investigation can move forward without the cooperation of the state, because the only issue is whether there is enough evidence to support an indictment. And if that evidence is secured locally by witnesses who step forward within the Philippines, and that evidence is sent on to the Hague, then the evidence will be available to support an indictment. Now, for a trial in absentia, well, you are correct, Pinky. The rules of the court do not allow a trial in absentia, but that is for the trial proper. Up until then, which means that in the course of the investigation, in the course of the filing of the charges, and up to the confirmation of charges by the pretrial chamber, that can be done without the participation of an accused who refuses to simply participate in the proceedings.
Does that mean that if it actually proceeds to the trial stage, what happens if the government refuses to participate? When you're saying that it is not allowed to have a trial by absentia during the trial chamber or trial division or trial stage?
If the person is never in the custody of the court, then the trial simply does not begin. The court does not even form a trial chamber for that case. And it will wait for the time when the accused is either captured or surrenders to the court. And
so, Judge,
and in the experience of the court, by the way, Pinky, a warrant of arrest might remain outstanding for 5-10 years. And in one case I have handled, after 10 years, he was actually captured.
So to be clear, during the pretrial chamber, the pretrial investigation, this is the part where they can issue summons and arrest warrants. This is the stage by which arrest warrants can actually be issued.
Yes, in fact, Pinky, that is the end result of the investigation. So they will not.
I see.
Right now, what we have is that the prosecutor asked permission from the pretrial chamber. Your Honors, can we have permission to proceed to a formal investigation? Because that is a check in the court against prosecutorial discretion, against prosecutorial abuse. And then the court says, okay, we have looked into your request. We think there is a reasonable basis to proceed. Please proceed. So that is where we stand now. They are just about to start. They have just received permission to proceed to an investigation. They will now investigate. If they have enough facts against a person, they will file the charges and issue the warrant of arrest.
But who issues the warrant of arrest? Is it the prosecutor asking the judges of the pretrial chamber?
The prosecutor will ask the court to issue a warrant of arrest, and it is for the court to issue the arrest order.
Yeah, and the court is composed of 3 judges of the pretrial chamber or pretrial division. Does it need a unanimous approval, or is it a majority?
Okay. No, the decisions are taken by majority, and The court is a mix of civil law and common law. Judges in the more traditional civil law systems, there is no room for dissenting opinions. But this is a court which has influences from both. And the common law guys basically have started issuing dissenting opinions.
I
But yes,
see. Again, we need.
it's a majority vote.
It's a Oh, is it a majority or unanimous?
Right, majority is enough.
Majority is enough. All right. Again, we need to take a very short break. The Source will be right back. Judge Pangalangan, I have 2 minutes left and I have a few more questions. Prosecutor Kamir Khan is supposed to be the one investigating this. Can we expect that the investigation has actually begun?
Well, yes, he was. It was his office which asked for permission to investigate. Now they have received the permission, and I will expect them to move forward. And by the way, the prosecutor of the incumbent prosecutor, Mr. Khan, has actually been a visitor to Manila. He has lectured before the Philippine Judicial Academy, and yes, so the Philippines is nothing. It's not some. It's not too alien for him in that sense.
Yeah. What about evidence that they need from witnesses? Are notarized documents on behalf of their lawyers? Will that suffice, or is there a need to appear in person or through Zoom? How can we expect the proceedings to be carried out?
Yes. Well, for the investigation, Pinky, it can actually be done via online video mechanisms. In fact, even for the trial, I have sat in the trial, the last trial in which I sat, which ended in May of this year. We received evidence. Witnesses testified by video link from Uganda, where they were. So if we can do that for a full trial on the merits, certainly we can do the same thing for a pre-trial. And the statements can be taken locally. They can be sent to The Hague. And those statements, under certain safeguards, can certainly be entertained as part of the record of the case.
And as a last question, if you were to approximate, how long do you think this pre-trial will last?
Oh, well, if I just go by the cases in which I have sat, maybe 1 year, a year and a half, because I'm sorry, I'm talking about the investigation, Pinky. But for the trial proper, well, I've got to tell you, the last case in which I sat, we began December of 2016. We had 4,500 rape and murder victims, and we sat as a chamber until May of this year. So for me, these are mass atrocity crimes that we deal with, and for a case, a large scale crime against humanity with thousands of victims, 75 charges, etc. It took quite a while. 3 years for that. Right. More than 3 years.
Okay. Retired ICC Judge Raul Pangalangan. Good to see you again, Judge.
Thank you.
Take care of yourself.
Me.
Thank you. And thank you for joining us here on The Source. I'm Pinky Webb. You're watching CNN Philippines.